start, sir?
You can.
Yeah. Good evening, friends. And today, it's a proud moment that being from Punjab and Haryana High Court, we have a former judge from Punjab and Haryana High Court, Justice Surinder Gupta, whose court was always a pleasure appearing before him, and his knowledge could be seen while we were addressing before him, and his judgments also spoke the volume. And today's session is quite relevant, and that's why when we connected with Justice Surinder Gupta, a former judge of Punjab Haryana High Court, made him a request that let's take some session forward, and why not share that knowledge which he has all seen throughout his legal journey. An opinion of handwriting expert, the value, relevance, and admissibility is a relevant topic not only for the professionals, but even otherwise in day-to-day life, wherein there's a connection with the legal journey. Without taking much time, that we know that since it's a weekend, we would request Sir to take the journey forward and share his knowledge. Over to you, sir.
Thank you, Vikas. Are you hearing me? Here, Vikas and his team,
Fine, sir.
And his team of Beyond CLC. Dear participants, good evening. I'm thankful to Vikas ji, who has given me an opportunity to be with legal luminaries for today's session. I must compliment Mr. Vikas and his team, who have been taking great pains in arranging such type of talks. I must share that whenever I have to make my opinion or update myself on any topic, I just open the website of Beyond Law on YouTube, select the topic, hear it, and I always find it very valuable and informative to me. Mr. Vikas and his team deserves great applause and compliments for their efforts. I was suggested the topic of today because it is very relevant. The opinion of handwriting expert, value, relevance, and admissibility. As you all know, that in routine, we have to deal with the forged documents, disputed handwritings in civil matters as well as in criminal matters also. It's very difficult to prove a forged document, and when a party denies its handwriting or signature on a document, law always requires direct evidence, and in the absence of direct evidence, it looks for the corroborative and circumstantial evidence. Opinions are not relevant evidence in any case, whether civil or criminal, or in inquiries and investigations, except for the exception created by Section 45 to 51 of the Evidence Act. Section 45 says that when some writing is disputed and the court has to form its opinion, in that eventuality, the opinion on that point of person specially skilled. Word used is specially skilled. It has not given any qualification of an expert, and the opinion of such specially skilled person is a relevant fact. We have to understand the language of Section 45. It used the words a person skilled, and his report is a relevant fact. Now, the question is, who is skilled? Nowadays, lot of courses, lot of advancement in the art of handwriting examination, fingerprint examination is there, which was not earlier. Whenever a document expert or a handwriting expert gives his opinion, he always supports it with reasoning. And that reasoning is before the counsel for both the parties and also before the court. And on the basis of that reasoning, the court has to make opinion. Here I recollect one of the case in the beginning of my career in 80s. I had just started the practice. I got a case where I was engaged by the defendant in a recovery suit. The suit was based on a per note. I inspected the file, took the photocopy of the per note, discussed the case with my clients. They admitted that yes, they have taken the loan, executed the per note. So I had no defense. I showed them the photocopy of the per note. On seeing that, my client told me that, sir, per note was executed by me, but not on the date mentioned in this per note. It was executed 8 months ago. In this month, I was not even in the city. I tried to make out tampering on the date, but was not successful. A very renowned expert from Patiala, he used to come to my city. I discussed the matter with him. He, on seeing the photocopy of the per note, could not make out any opinion. On my request, he inspected the file, took the photographs of the per note, and on the next date, when he came to me, he told me, Mr. Gupta, raise the plea of tampering in the per note. It is there on the writing. The figure 1 has been converted into 9. And it is clearly visible in the enlarged photograph. And this figure is also in the amount mentioned in the per note. And there is a lot of difference in both the figures. That report ultimately helped me. I raised the plea, and the report of opinion of the handwriting expert proved to be very valuable in that case. Here I also recollect one very important case. When I was sitting on the bench, I was hearing a matter in which the parties had been convicted by the lower court and their appeal had been dismissed by the appellate court. They are before the High Court. The brief facts of the case were that a sale deed had been executed by the owner of the land. It was registered on 17th of August. And the owner of the land had died on 14th of August. It was a very clear case that some forgery has been committed. And this is why the lower courts have convicted. But while hearing the argument, a fact came to the knowledge that this person who had died on 14th of August, he had executed two sale deeds, Both were registered on 17th. His legal heirs have challenged one sale deed, but not the other one. We tried to inquire why they have not challenged the other one. The counsel for the revision petition took the time, and a new story came up. We called for the other sale deed and found that both the sale deeds were bearing the thumb impressions, which appeared to be identical. A expert was engaged, his services were availed, and he told me, he gave the report that the thumb impression on both the sale deeds were of the same person. Now, this was showed that these two sale deeds were executed by the owner of the land. Then further inquiries were made. Case was sent back to the district cap for inquiries. And surprisingly, the report came that the sale deeds were executed on 12th of August. The thumb impression was affixed on 13th of August. It was the party had gone to the office of the sub-registrar on 13th of August, signed in the register of the sub-registrar on that day, and have gone back. The sub-registrar was somehow busy with the 15th August function, and he could not come to the office. After 15th, 16th was the holiday, and he registered the document on 17th. All these facts came on record during inquiry, and ultimately those persons who faced the conviction and remained in jail for a long time, they got the relief and were acquitted. So this is what I want to make out is that this is the value of the report of an expert, which helps the parties, which helps the court in reaching a proper conclusion. When I joined the judicial services in the year 1983, I had been getting so many cases where we have to make our opinion on the basis of the report given by the handwriting expert. I always wanted to know how they examine what is in their mind, what remains in their mind when they are preparing the report, what they think, whether their report will be accepted by the court or they remain under the pressure of the party which engaged them. Fortunately, I got a chance to visit the house of a very eminent handwriting expert in Delhi. I asked him to show me his lab. He told me that they don't have any lab because they are not using any chemicals, rather base their opinion on the examination of document with the help of magnifying glasses, microscope, enlargers, etc. I went to his office and found that there were 2-3 tables lying there, on which there were a number of microscopes, magnifying glasses, ultraviolet lights, etc. were lying. There were a number of books relating to handwriting examination in his almirahs. I also found a book by Albert Osborne who is considered to be the father of the science of handwriting. He was born in America in 1958 and died in 1946. He is acknowledged as an expert in this field, and even today, his scientific conclusions are still studied, researched, and his expertise is still quoted. I found his book, Question Documents, written in 1910, Mind of Juror, written in 1937, and Problem of Proof, written in 1922. I inquired from the expert how you examine a document. He told me the entire procedure, that we first take the photograph, then prepare the enlargement of that photograph, then compare it with disputed document, and make sections of the photographs, again minutely compare it. I told him whether you do it alone or you have a team. He told me that they have a team. Before giving the opinion, they all sit together and try to make out an opinion about the document, and then a report is prepared. I wanted to know from him that there is a impression that an expert is always under pressure of the party which has engaged him, and he has to give a report in his favor. Though the judicial verdicts are different, but the answer of that expert was that they are never under the pressure of the party which is engaging them, because before engaging them, the party had already taken their opinion. They bring the disputed and admitted handwriting before them and have the opinion as to whether their report will favor them. If the report is favorable, then they go to the court and engage them through court. Otherwise, they just avoid to engage an expert. My one more question was, what type of documents are generally the subject matters of their reports? He told me that usually they get some wills, agreements, sale deeds, check, account books, rent note, lease deed, forged document like school certificates, SC/BC certificates. Police also comes to them to have their opinion on the suicide note, threatening letters, bills, property documents, and one more thing, which is no more prevalent now. He told me that sometimes the parents had been coming to him with the love letters written to their ward. They will bring the handwriting of 3-4 persons and try to know from us as to who has written the love letter. Now, no letter is written and everything happens on the chats and mobiles, social media. So that part is gone. I also tried to inquire from him that when they give a report, whether they have any thing in their mind that this report will be accepted by the court, or any comments will be recorded against them on the basis of this report. His answer was very simple and clear, that when they give a report, they don't favor any party. They do the best, try to give the report as per their ability. Then they go to the court, face the cross examination, and after coming to their office, they get involved in other cases and forget about that case. It is only sometime the party come to them and tell them that the report has been accepted by the court. So it is never a tension in their mind that their report will be accepted or not accepted. Anyhow, I accepted his view, and it was a really very informative visit to the house of a handwriting expert, where I could come to know how they work, what they think, and what remains in their mind when they submit the opinion. Now, coming to the legal aspect of opinion of the handwriting expert. For sending a document to the handwriting expert, we require two types of writings. One is disputed handwriting, and the second is admitted. So far as the disputed handwriting is concerned, it is on record, it is on file. But admitted handwriting is to be proved. And every legal professional must take care that admitted handwriting is duly proved. Now the question is how it can be proved. Firstly, admitted handwriting can be proved when a party admits it. Secondly, when a person is examined who says that I have seen this writing being written by this person. And thirdly, when the court directs any party to give specimen handwriting. And fourthly, we come to section 47, which says that any person who is acquainted with the handwriting can prove it. I will read section 47, which says as follows. When the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person is a relevant fact. Means a person who is acquainted with the handwriting of anyone can prove it. Here also the opinion is relevant. I am talking of section 47 of the Indian Evidence Act. Here, during my long inning in the judicial field, I found that some counsels commit mistake. As in one case of a will, a testing witness had died. The party examined an official who was working in his office, in the office of the attesting witness, who said that I have been working with this fellow for the last 20 years and the signatures on the will are of that person. It was felt that yes, job is over. He committed a great mistake. That person is acquainted with the handwriting of a attesting witness is to be proved when he is proved when he says that yes, I have been working with this fellow for the last 20 years or any number of years. I have been seeing him writing and signing. I can identify his handwriting, and this handwriting is of that person. If this part is missing, then the handwriting is not proved. So one must take care that while proving the admitted signatures, he complies with the provisions of section 47 or proves it by direct evidence. Now, both the writings are duly proved. One is disputed, other is admitted. Court sends the same to the expert chosen by the party, and the expert gives his opinion. When the turn of the other party comes, they also engage the expert, send the disputed and admitted writing to that expert, who also gives his opinion. In many cases, it has happened that there are conflicting opinion on same handwriting, because the science of handwriting is not a perfect science. Every handwriting expert has his own caliber. So here becomes a problem for the counsel as well as for the court as to how to analyze both the reports. One is saying that the disputed handwriting tallies with the admitted handwriting. Both the handwriting are by same person, and the other report is vice versa. I have found that some of the judicial officers in such eventuality write down that both the reports are conflicting, that expert have been engaged by private expert have been engaged who have tried to favor their party. As such, I reject the report of both the parties. Here, the court commits a mistake. It is the duty of the court to give a finding, to record a finding. It has to take the assistance of the opinion of handwriting expert. Both have given the reasoning. The court has to go through the disputed handwriting, admitted handwriting, and then, as per the provisions of section 73, it can compare both the handwritings. So it has to find which reasoning is acceptable, which expert has not given a report as per the actual facts, and record a finding that the opinion of this and this expert is acceptable and other is not acceptable. The court cannot say I reject the opinion of both the parties, because court has ultimately to reach a conclusion as to which party is putting forth the two facts before it. There may be a situation where both the reports are so confusing that court is not in a position to make up its mind. court is not an expert. It has tried to compare both the writings, but could not reach any conclusion. Then what to be done? The court is again not remediless. It can opt for sending both the writings to third expert or to a handwriting expert of some government office. So court will be having a third opinion also, which will certainly help the court to reach a fair conclusion as to which report is correct and whether the admitted and disputed writing tallies or do not tally. So instead of writing that I do not accept both the reports, the court has to proceed further, and the counsel should assist the court in this matter when they find that the court has not been able to make out, or they themselves could not make out as to which expert is correct. They can move an application for sending the admitted and disputed writing to government expert. Now I deal with section 73 of Evidence Act, which also deals with the comparison of admitted and disputed handwriting. It says that the court can direct any person present in court to give his specimen handwriting or any figure or anything which is to be compared. This section is an enabling section. It enables the court to take the handwriting and compare it. This section, when we read it, appears to be very simple, but it has gone a long way to give interpretation to this section. Earlier, the Calcutta High Court has interpreted this section by saying that this is an enabling section for the court if the court feels that it requires the handwriting of any person. It may direct the person present in court to write any word or figure for the purpose of enabling the court to compare it. Calcutta High Court said that no such writing can be ordered on the application of the police or on the application of one of the party to the litigation. This opinion of the Calcutta High Court was followed by Bombay High Court. It was also followed by Madras High Court, but Patna High Court did not agree with it. It said the taking of any writing or a figure is for the purpose of enabling the court to compare the same to reach a just conclusion. Court can take that writing of its own and can also order this writing or to be taken on the application of the police, prosecution, or any of the party to the suit. The matter ultimately went to the Supreme Court, and the Supreme Court in the case of State Delhi Administration versus Palliram decided that a court is competent to allow the application of the police or prosecution and give direction to any person for writing for the purpose of comparison. In that case, the Supreme Court formed a question before it, and that question was whether a magistrate in the course of inquiry or trial, on being moved by prosecution, is competent under Section 73 Evidence Act to direct the accused person to give his specimen handwriting so that the same may be sent along with disputed writing to government expert of question documents for examination, with a view to have necessary comparison. The Supreme Court answered this question in affirmative. I just discussed the brief facts of that case. In that case, the police had moved an application before the court to obtain the handwriting and signature of a person for the purpose of comparison. That application was allowed by the magistrate. That person, Palliram, went in revision before the Court of Session and it was dismissed. Then he went to the High Court. The High Court allowed his revision with the observation that the scope of Section 73 Evidence Act is very limited. The Honorable Supreme Court then set the law in motion and held that the court is competent to direct any person on the application of police, prosecution, or a party to give handwriting, because that handwriting is ultimately for the assistance of the court, because that opinion will ultimately come to the court. In that case, the Supreme Court also held that how a writing can be proved. Number one, by admission of the person who wrote it, there is no dispute. By evidence of some person who has seen him writing, that is again a direct evidence. In the absence of this evidence, we are left with opinion evidence. Opinion evidence is like opinion of handwriting expert under Section 45. Then opinion of the witness who is acquainted with the handwriting of that person, Section 47. And lastly, opinion found by the court on comparison of that writing, Section 73. The scope of Section 73 was ultimately settled by the Honorable Supreme Court. Then there is one Section 293 which deals with the report of the government expert in criminal cases. I am not going to deal with that in detail. And recently, Criminal Procedure Identification Act has been passed by the Union of India. It is just for academic discussion, not much relevant with the opinion of the handwriting expert. In that case, in that act also, that act came into force on 18th April 2022. As per section 3 of that act, a magistrate is competent to direct any person to give his handwriting and fingerprint impression, though these are required for keeping the record of the person arrested, convicted, or taken into preventive detention. But these handwritings and samples are again relevant if required for any comparison. Now, I have already discussed what can be done when there are conflicting opinions before the court. I have discussed that section 73 enables the court to do the comparison of its own and record a finding. But in the case of State versus Paliram, the court said no. The court should avoid, a judge should avoid to do the comparison of his own. Rather, he should take the assistance of the government expert or any private expert in the field. Another question that arises is whether the opinion of a handwriting expert can be relied upon without examining him in court. This question was dealt with in the case of Keshav Dutt versus State of Haryana by the Honorable Apex Court. It said no. The opinion of a handwriting expert is relevant only when he is examined in court and opportunity of cross-examination has been given to the other party. Again, an eventuality may arise, as in one case, the handwriting expert gave his opinion, and after that, before he could be examined in court, he died. The matter again came before the Apex Court, and in that case, it was the case of Swai Singh versus State of Rajasthan, 1986-3 SCC page 454. And the Honorable Apex Court that in that eventuality, the option before the party whose expert has died is to engage another expert, take his opinion, but in that opinion, that expert can support the opinion given by the earlier expert who had died. Now, a very important factor I will like to do is cross-examination of the expert. During my 25 years of service in the lower court, I have found that many lawyers avoid cross-examining an expert. The reason for that is that they don't consider themselves to be the expert. They advise the party to engage another expert for examination of that handwriting expert. My experience tells me that this is not a good practice. Lawyer is the master of the case. He knows what facts he has to bring on record. He knows what type of question he has to put to the expert. He is aware that he has not to put long questions. He is very well aware that expert is not to be given any opportunity to give any explanation. While the expert engaged by the party is not aware of all these things, he is aware only of the report, admitted and disputed signatures. Sometimes he brings certain facts on the record which do not help the party. So, in my view, every lawyer should prepare himself for questioning the expert. Before that, he can certainly do the research work about that expert, can have the access to his earlier reports, opinion of the courts about him, make his line of cross-examination, putting him very brief questions. But I'm sure that if the lawyer is himself cross-examining the expert, he will do it in a better way. I think time is almost over. It is 5:47. I will wind up within 2 minutes. Another question that arises before availing the services of an expert, what precautions should be taken? As I have already discussed, that a lawyer must see that the two sets of writings are before the court, admitted and disputed, and admitted writing is duly proved. Secondly, the opinion of the document expert, handwriting expert, is very relevant when there is a case of traced forgery, superimposition, tampering of writing, because these are the cases where he can give a definite opinion. Traced forgery, the opinion given by an expert is near to perfection. Same is the case of superimposition, because in that he can analyze by enlargement and other ways that there is a superimposition, because in traced forgery there are pen lifts, pen pressures, so many things which he can prove. Same way in tampering of document, as I have already discussed in the beginning, that can be proved, and the report of handwriting expert is very near to perfection in such cases. One of my discussion earlier, I was asked a question that whether the age of the writing can be ascertained. The answer to this is in positive, yes. Age of the handwriting can also be ascertained. It is easier when the writing is with pen and pencil, and difficult when it is with ball pen or typed, because on the writing of pen and pencil, there are weather effects. It suffers with the passage of time, fades with the passage of time, and it's easier to determine its age by using the dating system. In the same manner, the age of the paper on which the writing has been written can also be ascertained. These are the facts I have discussed about the writing opinion of the handwriting expert, which relate to the documents on court file. I was going through some book of an expert where I found an interesting chapter where he has written about the opinion, his opinion given to the public institutions. I will just discuss in short a small story I read in his book, just to make out that the opinion of the handwriting experts are not only relevant in the court, on the court file, it are helpful. These are helpful to the other institutions also, public also. He wrote that he was engaged by a college. The story was that on the notice board of the college, somebody write the name of a lady lecturer, and below that the words "I love you." There was a lot of ho-halla in the college. A committee was formed to trace who has written it. The committee, after recording the statement of several persons, shortlisted 3 male lecturers and sent their writing to the expert, who gave the opinion that none of the writing tallies with the writing on the notice board. The committee again sent the writing of 3 more persons. The same report came. Ultimately, the committee met the expert and discussed the matter with him. The expert advised them to give him the writing of some lady lecturers in the college. The committee was not willing. They said, why the lady lecturer will write such thing on the notice board? But on his persuasion, they sent him the writing of 3 lady lecturers, and immediately came the report that this writing tallies with the writing of this lady. The committee called that lady, and ultimately the report of the committee was that the writing was written by that lady because she was feeling jealous of that lady and just wanted to defame her. Report of the handwriting expert was very useful in that case for the college, and the problem was resolved. So while winding up, I will just suggest the brothers, the young lawyers, that while availing the opinion of handwriting expert, they must make it sure that the admitted handwriting with which the disputed handwriting is to be compared is duly and fully proved on file. They may not fail on that score in any manner. Otherwise, the entire effort made by them, the report obtained from the handwriting expert, will not be of any use. The report of handwriting expert is always valuable. It is relevant and admissible, and we must make full use of it without keeping in mind that the handwriting expert will give the report in favor of the party which has engaged him. Thank you very much. Over to Vikasji.
Thank you, sir. And the subtle manner in which you have explained a topic with so much ease, I can feel that even a common man who is watching this webinar can actually learn from it. Meanwhile, we had few questions on the chat box. Vikas says, is report of a private lab handwriting expert with report that handwriting does not match looking at the natural variation, but more samples can be taken, is same having probative value of evidence, i.e. this report can be used for summoning being forged documents were prepared by using handwriting of the other person.
So far as the opinion of the expert is concerned, that he requires some more writing for the purpose of comparison, that may be taken care by the court. And if the person is present, is alive, court can certainly ask him to give his handwriting signatures or figures, whatever is required. But in case that person is not alive, from where you will get? Either the party had to find out some other document on which that his handwriting is available, and sometimes the party is not in a position to find the documents. So the party loses the chance. The option before the party in that case is either to engage another counsel, engage another expert and have his opinion, or request the court to send the disputed and admitted handwriting to the handwriting expert, government handwriting expert.
Kamra says, is there any expiry limit of handwriting sample?
So far as the handwriting sample is concerned, it doesn't have any expiry limit, because when you will send the same to the expert, he will give the report within a limited time, maybe month, 2 months, 3 months. Even if the report is delayed by a year, the sample doesn't expire.
I asked how to check the forced signature in cases where original document is deliberately lost by the accused and signatory is dead meanwhile.
Original document is deliberately
lost, or you can say that he's not showing it and signatory is dead.
Now, we must understand that the opinion of the handwriting expert is based on the original documents in normal course, but there is no bar that the signatures on photocopy cannot be compared. We can read an article of Diwan K.S. Puri of Patiala, written long time back, where he said, yes, the comparison can also be made of the writing on photocopy in the absence of original. Here, two facts will arise. One, if a party is withholding the document, inference goes against it. So in that event, the other party or prosecution can certainly take the benefit. Secondly, if that party is withholding the document, the prosecution or police can certainly go with the photocopy or any other secondary evidence and get his signatures or writing compared.
How is the how is the age of the signature calculated? Is there any manner for calculating the same?
Yeah, I was just discussing. I have cut it short. The age of the writing or a signature can be determined. I was discussing it. If it is written with the ink, now there are different type of inks. Every ink has its own composition. So the expert firstly decipher the type of ink used. Then with the dating method, direct and indirect dating, they try to find out the age. As far as the literature on this point goes, the exact age may not be revealed, but approximate age of the document, of the writing, can be ascertained by way of dating method. But if this writing is typed writing or with ball pen, then it is very difficult. Not bit difficult, but very difficult.
And slightly, they say that you can also calculate it by, though it will be difficult, by the age of the paper also.
The age of
unless the paper is also quite old, then things are different. But they say that it helps you to buttress that.
You can also determine the age of by fiber analysis. You can we can with the help of the forensic science, we can always determine the age of the paper. And sometimes it's many cases have come to notice where the age of the paper is less than the age of the writing.
This is Vikas says it can be done by carbon dating. Venkat says, letter written but thrown in a dustbin into 2 or 3 pieces. But the opponent takes it out from the dustbin and produces it after 10 years. Is this valid?
If question is the paper thrown in the dustbin, he is producing it as disputed handwriting or admitted handwriting. Either way, he has to prove it first. It doesn't matter. It is not irrelevant whether the paper is lying in the dustbin, in a paper book, in a file, or anywhere. He has to prove it. It is to be taken either as a disputed document or as a admitted document. So, as the party raises the plea, but the fact is to be proved. It is irrelevant whether the paper is lying at which place. So, his question that if the paper is lying in a dustbin, how does it matter? Paper may be lying in an almirah, paper may be lying in a file or anywhere else.
Dr. Pandey, he says if a person signs himself on the check with different style and pressure of writing and later denies the signature, how to ascertain the genuineness of the signature of that person?
That is a very difficult field. Many people do like that. They deliberately write in a different manner. Now, the question is how to determine that he has written him. A person can certainly request the court to ask the person who has signed the check to write in the manner, to write the way it is written on the check. One thing. Secondly, the writings has its own edges, pen lifts, mannerism, and many other things like that. The expert, by making the sections, can certainly find that he has tried to write us in a separate way. But again, I tell you that the writing can be ascertained. Albert Osborne, he wrote in 1920 that no two individuals can produce exactly the same handwriting characteristics, even if he has written in a different manner, tried to manipulate, but still the characteristics can be found in his writings. So it is more difficult, but certainly the expert can find it.
We have taken the questions. One, Mr. Manoj has asked, but that is a sub judice matter. So on sub judice matters, we don't take, because lest he says that this was the opinion given. So thank you, friends, for connecting with us, not only on the YouTube, but also on this Zoom platform. And we are indebted to Justice Surinder Gupta, former judge from Punjab and Haryana High Court, sharing his knowledge. As I said, that appearing before him would always show, and his judgment always showed his knowledge. Today, those who have heard him for the first time would endorse that opinion that his knowledge sharing was so simple and straight, which could straight away make things understand to everyone. Everyone stay safe, stay blessed, and have a good weekend. Namaskar.
Thank you. Namaskar.